Good morning and welcome to the second in our Parent University series, Child Support Key Points for Custodial Parents. And I just want to put things in context. When child support first became federally mandated in 1975, it really was a cost recovery program focused on paying back government benefits. The argument of the era under government at that time was, well, we're paying all this money out for benefits for people, cash assistance, that kind of thing. But we should be getting something back with regard to child support. The parents should be supporting the child. And it was a very different program then than it is now, and it's much more a child-focused program that recognizes the importance of both parents, even though they may not be together, they may not be in the same household. And again, as we covered last week, the custodial parent is defined as being the parent with whom the child spends the majority of the child or children's time. So we are now seeking to provide services to the entire family, both the custodial parent, the children, child or children, and the non-custodial parent. So next slide. Let's take a quick look at the benefits of child support. First off, no support flows unless and until legal parentage is established. And that's important. That gives the child inheritance rights. It also gives the non-custodial parent a say in the child's future with regard to schooling, medical care, potentially adoption. And establishing parentage for the custodial parent is the first step in establishing an order of support. As I said, without parentage being established, there cannot be a child support order put in place. Child support also guarantees regular payments, ideally, based on the NCPs income, and provides formal documentation of financial support, so there's no squabbling over, you forgot to pay me last week. Yes, I did pay you. No, you didn't. That kind of thing. Collections are enforced, and we'll take a look at that a little bit automatically by the child support database. Will start various enforcement actions against the non-custodial parent automatically if the individual falls behind by a certain amount. And lastly, and most importantly, the cost of raising a child is shared by both parents, and particularly for low-income families, child support is a major anti-poverty program, and it affects about 1 in every 7 children in New York City. Let's go to the next slide. This is the overview of the child support life cycle, if you will. And it's a long relationship that we're likely to have. From the time a case is opened, the first step is to establish parentage if it's not already established, then to get an order put in place through family court, followed by collecting and distributing support. If a child support case starts, for example, when a child's 2 years old, that means that we will be administering that case probably until the child turns 21 and emancipates. So it's a long relationship between the custodial parent, the non-custodial parent, and the Office of Child Support Services, OCSS. There's also enforcing or modifying an order. We're going to talk about that a little bit in a moment. Let's go to the next slide. So the start of the process for custodial parents depends on whether or not the custodial parent and the children are receiving cash assistance. If they are, then the custodial parent is required to come to one of the OCSS borough offices. We have borough offices in every borough except Staten Island. Custodial parents in Staten Island have to come into Manhattan to attend the borough office meeting. custodial parents that are not receiving cash assistance applies to family court, and OCSS has an office in all 5 family courts that are located in each of the 5 boroughs of New York City. Whichever route in, OCSS and the custodial parent sit together and complete the child support application, which gathers information about the custodial parent, about the non-custodial parent, about the children that are on the case, including birth dates, birth records, birth certificates when available, all kinds of supporting material. And I should add that our services are available to all custodial parents, regardless of immigration status of either the custodial parent or the non-custodial parent. OCSS does not look at that, does not report people whose documentation is not in order. We serve all people. We also serve guardians, by the way. So the custodial parent could be a grandparent or a guardian, in which case there may be 2 non-custodial parents. So to draw out the process in a little more detail, the custodial parent provides information about the non-custodial parent, and we use various tools to search for the non-custodial parent. Now, there are times when the custodial parent can't provide a tremendous amount of information about the non-custodial parent, which means if we cannot locate the custodial parent, we put the case on hold. While we continue to search, and there's a branch of OCSS called Centralized Locate, which is very good at locating non-custodial parents. And often after a period of time, they turn up in a search engine or on social media, or a social security record pops up, or an employment record pops up. So we are good at locating non-custodial parents. Once the custodial parent is located, we then file a petition, and that petition would either be for a finding of paternity and support if paternity is not clear, or it could be just for support if paternity is already established. When is paternity already established? Principally when either the couple is married when the child was born, or the birth mother and the father of the child sign an acknowledgement of parentage, usually at the hospital. It's called an AOP. Notice I'm using the term parentage instead of paternity. It covers a wider variety of the way families are formed these days. Then from the time the summons is sent to the NCP, and of course the NCP has to be put on alert that that a case has been started. In normal times, it takes 4 to 5 weeks before there's a hearing in family court. Hearings have been a bit delayed because of the courts being closed for the pandemic, but things are opening up now, and we expect that we'll get back to a regular schedule in the near future. Now, it may be necessary to return to court. Perhaps someone doesn't show up, or the NCP doesn't bring all the documents that have been requested. So there may be several appearances in family court, finally resulting in a child support order. And I should note that the family court for child support is separate from portions of family court that deal with children with behavioral issues, or foster care questions, or custody issues. The support magistrates that deal with child support just address child support, and you do not need a lawyer to appear in family court on a child support matter. Now, there is an alternative to going to court with all the uncertainty that that involves. And this is something that OCSS developed during the pandemic. which is a stipulated agreement. The parents can come together with a customer service representative from OCSS to fill out an agreement. That agreement will spell out child support using the exact same guidelines that are applied by the support magistrate in family court, because there's a very set formula. So it's not as if you participate in this alternative, you will avoid, or not avoid, you'll end up with a different result than you would in family court. It will be the same. The agreement then gets sent to court. The hearing is scheduled. The NCP has to be served a summons because we have to preserve his rights. But that means the parents can go to family court already knowing what the result will be, which is a much less stressful arrangement and speedier. It involves one appearance and boom, you have a child support order. Same amount of support, but because the parents, in situations where they can work with each other, have finalized the agreement in the much more pleasant ambiance of working with customer service, which by the way can be done over the telephone. It is a less stressful and easier way to work through an arrangement. Let's go to the next slide. So, when am I going to receive child support and how much am I going to get? The non-cash client, and remember the distinction between a cash client and a non-cash client is that cash assistance is being paid on behalf of the children. That makes someone a cash assistance client. If the custodial parent just comes to family court and says, my ex isn't paying me child support like we agreed in the divorce agreement if they were married, or I had a child with my boyfriend and now we're not together and I need child support. The amount of cash, the amount of child support, 100% of that will go to the client along with any debt payments for arrears or retroactivity. There is a $45 annual charge for our services for non-cash clients, but that's only after we bring in at least $550. So along with a free ride on the Staten Island Ferry, it's a pretty good deal from the city of New York. For cash assistance clients, they receive their benefits and they can also receive a pass-through if the non-custodial parent makes payments on time. And that's designed to be an inducement to the non-custodial parent to make regular payments. And that's up to $100 for one child, in addition to the cash assistance benefit that's set out for that family, as long as the child support payment is at least $100 a month. For 2 or more children, the pass-through is $200 maximum. So either way, the benefit of child support when it's being paid flows to the custodial parent. And by the way, the funding is generally comes to a benefits card, an EBT card of some sort, and money can start flowing as soon as several weeks after the court issues an order of support and we get that set up in child support. Let's go to the next slide. I just want to spend another moment on the importance of parentage. As I noted, it can be established by marriage or a signed acknowledgement of parentage, or it can be settled in court, either by the NCP telling the support magistrate, yes, Your Honor, I am the father of this child, or if there's question or doubt or dispute, there can be DNA testing, which is low cost. Now, I also want to add, we covered this in the prior session, but I want to swing back and just stress that we have protections in place if there's a concern for the safety of either the custodial parent or the children because of issues such as domestic violence. It's possible to file for a court order and keep your location confidential. The non-custodial parent will know what court, what borough the proceeding is being held in. There are now hearings being done virtually. So we go to every degree that we can to make sure that the custodial parent is protected. And as I mentioned earlier, there are benefits for establishing parentage that may benefit the child later in life because of inheritance rights, Veterans Administration benefits, so even Social Security. So establishing parentage is important. Let's go to the next slide. I want to quickly show you a little bit about the process as the NCP experiences it, so that if you're in a position where you are going to be explaining to the NCP what's going to happen, the NCP will receive a summons at either a residential address, or a summons can be served at a place of employment. There's a hearing in family court. If the NCP does not appear, then the sheriff will serve a summons to make clear that appearance is mandatory. And there may be, as I mentioned earlier, returns to court for further documentation, establishment of parentage, ultimately a child support order, and child support being deducted from the paycheck or paid directly by the NCP. I also want to stress that it's important and very beneficial if the non-custodial parent participates in the process, because that will guarantee that there will be an accurate amount in the support order that the NCP can reasonably afford to pay. It's also worth pointing out that the NCP, again, must cooperate with the process, and that is beneficial for the NCP. Let's go to the next slide. So, what is withheld from an NCP's income? And the answer is the obligation amount that's spelled out in the order. The order will say the NCP is directed to pay $125 every 2 weeks. There will be an add amount. And this is an important thing to recognize, which is child support is due from the date that the petition is filed in court. So if there's a lag time, which there's going to be some lag time, if there's a lag time from the date the petition is filed to the date of the court order, the court will address that by creating retro amount. There's a case that we use frequently where it took 6 months to establish the order, which is a little bit long, but it was complicated by the fact that the address was incorrect, so the NCP was not properly served initially. The additional amount, we call it the add amount to reduce arrears or retroactivity, is 50% of the add amount. So for example, if there's a retroactive amount of $600 and the obligation amount is $100 a month, then 50% of that $100 a month would be an additional $50 for $150 withheld from income for a period of a year, because 12 times 50 equals 600. That would wipe out the arrears as long as regular payments are being made. Next slide. And if regular payments aren't being made, what are the options for the non-custodial parent? Well, the good news is all the administrative enforcement actions that OCSS has has available to use start automatically. The custodial parent doesn't have to do anything. the NCP is notified by mail that an administrative action is going to be taken in almost every instance. And they can challenge any administrative action. Perhaps we have the wrong person, perhaps our numbers are wrong, perhaps a keyboarding mistake was made. It doesn't happen often, but it does happen. So the custodial parent doesn't have to take any action when the NCP misses payments. The child support database will take care of all of that. However, if administrative actions are unsuccessful, or if the custodial parent in a non-cash case wants to, then judicial enforcement actions can be initiated. And those can include reducing fines to money judgments with interest. It can include, in very rare cases, but it's not out of the question, incarceration. It can include the NCP being ordered to attend a mandatory job training program, because maybe the NCP is not paying because he or she does not have a job, and we will help them do that. And judicial actions can be somewhat onerous. Let's go to the next slide. Now, orders can be modified in either party without a lawyer, using do-it-yourself forms that are available, and possibly, if you need it, with the assistance of customer service staff from OCSS. Either party can file a petition to modify an order downward. The NCP loses his job, has his hours cut, or upward. Some NCPs will voluntarily provide that information. It may be that the custodial parent gets word on the street that the NCP has gotten a promotion or a new job. Either party can file for upward or downward modification. Frequently that comes because of job loss or decreased income. We saw a lot of that during the pandemic. Incarceration, if an NCP becomes incarcerated anytime after October of 2010, the NCP can get a downward modification. It could also take place from a sudden disability, or there could be a change in custody, in which case the order, rather than being modified, will be terminated if the former NCP becomes the CP and the former CP becomes the NCP. Now, I should also add, this came up last week in our general presentation, an order can also be modified by a cost of living adjustment, a so-called COLA, without going back to court. The trigger there is that the CP can request a modification, a COLA, when asked about it, but it has to be the CPI, the Consumer Price Index, the Urban Consumer Price Index, the CPIU, has gone up at least 10% from the date the order was established or last modified. Now, we used to say, and in fact, I'm looking at the Custodial Parent Handbook, which says it can take 4 to 5 years to reach the required 10% increase in the CPI. However, in the past 12 months, the CPI in 12 months has increased 7.9%. So we're going to be seeing a lot of COLAs in the coming years. If the custodial parent is a cash assistance client, the COLA will go into place automatically as soon as the case becomes eligible. For custodial parents that are not on cash assistance, they will be notified by mail when their cases meet the requirement for a COLA, but they have to respond to the notice to receive the increase. I know that's a lot. Let's go to the next slide. Now, in the same way that we've developed during the pandemic a stipulation process for initial court orders, we also have MOTS, modified orders through stipulation. And again, this offers parents the opportunity to discuss and reach an agreement on changing an existing child support That gives, this is done by our customer service team. It gives both custodial parent and non-custodial parent the opportunity to ask questions, to make sure that the orders are aligned with the NCP's income. It shortens the time in court. There's more support because you're not in a court setting with a support magistrate and a clerk and a busy calendar. It fosters open discussions between parents, and it decreases the number of orders made on default when the NCP doesn't show up and the judge just says, okay, here's what it's going to be. Now, next slide. We've talked a lot about modifying orders, and we will, by the way, be distributing a copy of this presentation to everyone who attends today. So the reason I mention that here is because the underlined things in blue that you see are links that will be clickable. So to get started modifying the order, you can reach out to the state helpline at the phone number indicated in the top left, or I advise specifically emailing child support OCSS at the rather lengthy email address listed below, or visiting our customer service center, which is now open at 151 West Broadway, or by mailing HRA OCSS at a PO box at Canal Street Station. The links to Family Court on the right provide access to forms, including the forms for upward and downward modification. Next slide. Now, I want to stress that we know, and there's a lot of debt, there's a lot of unpaid child support. Some of it owed to Department of Social Services, and we can do things about that to help the NCP. A lot of it owed directly to the custodial parent. We know that debt increases the likelihood of current support not being paid. It escalates the conflict between the CP and the NCP. It means in all likelihood the NCP is likely to have less contact with the children, and it means less income for low-income custodial parents. So we're very interested in addressing debt. We have the power to forgive debt that is owed to Department of Social Services, and child support is payable to social services while children are receiving benefits. Money that's owed to the custodial parent, we do not have the power to forgive. So we can't say, oh, Mr. Jones, we're going to forgive half of the money you owe to Ms. Smith because you can't afford to pay it all. No, the money's owed to Ms. Smith. We don't have a say in the matter. Next slide. However, we do offer mediation services where, and I know this is not the case for all couples or all parents, but there are custodial parents and non-custodial parents who have a decent working relationship. And we have trained mediators who can address child support debt owed to custodial parents and help parents potentially come to agreements about past due child support, future child support payments, and also issues related to custody or visitation or communication and other types of conflicts. So we're here to help in many different ways. Let's go to the next slide. And again, I want to stress, child support, the Office of Child Support Services is here to help everybody, custodial parents and non-custodial parents, with general questions, specific questions, helping apply for child support, understanding payments and obligations, modifying orders. Something as mundane as changing an address, but that's very important because we need your address to be able to be in touch with you, notify you when necessary. We also deal with enforcement measures, avenues of relief for certain enforcement measures, debt reduction, employment programs. We have a number of them available right now. At each office, we will help you, even if you're in the wrong office. We have a policy now called no wrong door. So you show up anywhere, And rather than saying, oh, no, you're supposed to be somewhere else, that office will help you to the extent they can, tell you what you need to get and where to go to finish what you need to do if they can't do everything for you. Next slide. Now, again, we're going to be distributing this to everyone who attends today, and you will get clickable links to these very valuable resources. The HRA website that has child support website that has all kinds of useful information and videos. New York State child support, not quite as user-friendly as our website. The OCSS playlist of topics on YouTube. How to request a phone appointment with OCSS. It's a short video, very clear. Managing your child support. That's a detailed information about debt programs for non-custodial parents. The handbooks that I mentioned earlier for NCPs and CPs, filled with information. I really encourage you to get the handbook for CPs if you're a custodial parent. You can contact us at the email address. That really should be a live link here. It's a live link earlier in the presentation, but Izzy, maybe you can make a note to make this link live on this page as well. And now, by the way, you can apply for child support using our mobile application, which is something new that we're quite excited about. Let's go to the next slide. Okay, I also want to take a moment to call to your attention an outfit called LIFT, which stands for Legal Information for Families Today, and they can be reached online at liftonline.org. They have an office in every family court, but you can also work with them now online. They will not be your lawyer, and you don't need a lawyer, but they can give you good, valuable information. And for custodial parents or non-custodial parents who might not have a computer in the home, they have tech support available in their office in Brooklyn, which is in the Metro Tech area, very close to family court.